Well, let's now turn to the advisory and ASIC enforcement activities back in focus, with Macquarie entering an enforceable undertaking over Shield Master Fund. It is a rare move post the Hayne Royal Commission that combines investor redress with governance reform. Let's get across the detail. Jonathan Steffanoni joining us from Legal and Prudential. Jonathan, welcome back.
Great to be here again.
So this saga is dragging on with so many people have done their dosh with the Shield Master Fund. So an enforceable undertaking, what is that exactly?
So an enforceable undertaking is one of the many enforcement tools that ASIC has at its disposal. It was commonly used prior to the Hayne Royal Commission. The undertaking is essentially a commitment from the entity which is being investigated to do certain things. The undertaking also will involve the regulator not taking further regulatory action, so not seeking civil penalties against the entity.
So in plain language, is this the regulator in the form of ASIC saying, listen, you need to do everyone a favour, do the right thing, otherwise, if you don't, we'll take action?
It is a negotiated outcome, so we could speculate as to what went into that conversation, but we know that the enforceable undertaking, which has been published by ASIC and is subject to court approval, it does include Macquarie admitting that they had contravened some of their legal obligations, so that will certainly be relevant in their thinking before going into this. They also commit to providing compensation to bring victims back to the position that they would have been had this incident not occurred. And it also includes a commitment from Macquarie to engaging an independent expert to review their investment governance practices. So on the one hand, it provides Macquarie with some certainty that ASIC is not going to take further legal action against them. It provides ASIC with, I guess, the outcome that there's a specific focus on the area where these issues have arisen. And for the victims, it provides restitution back to the position that they would have been had these issues not occurred. So some good outcomes. If I look at it, I feel it is a better outcome than a civil penalty proceeding, which ASIC would run, I think would likely be successful in getting penalties imposed on Macquarie, which would be paid to government as a fine. It doesn't achieve anything in terms of compensating those victims that have been affected or addressing the underlying areas of weakness around investment governance.
Okay, so potentially win-win, certainly as far as those that have lost their money is concerned. So you're saying
Yes.
they will get 100%
That's
back,
what
those who invested via Macquarie?
Yes, those who have invested via Macquarie will get 100% back. The adjustment in there is for any withdrawals which they had already made. So they'll be brought back to the position that they would have been in had the investment not been made.
Yeah, and this once again, I guess, highlights the effectiveness of ASIC, just whether it has the teeth to actually prosecute, or in this case, not, but actually maybe even more effective. Look, you've got another case as well in terms of a super fund.
Yeah, there was another announcement from ASIC last week involving Rest Super. ASIC announced that they had issued 2 infringement notices on the trustee of Rest. This related to misleading and deceptive representations, which the trustee had made in correspondence to members. It was about their insured benefits. So they were essentially providing information that said that there was insured cover under circumstances where it should have been cancelled under some laws that came in about 5 years ago that were intended to protect small account balances. So these infringement notices are another enforcement tool. They're an easy one to grab at and usually used for less significant contraventions. They're very easy for an entity that receives them to deal with as well. They will get immunity if they pay the fines in them. The fines are much less than what would be received if they went to court. So it's usually a pretty easy decision for the trustee to just pay the infringement notice and move on.
Now, Jonathan, elsewhere, we've been reporting today that Bitcoin hitting a new record over the weekend.
Mm-hmm.
Now, this has been an issue in terms of investing in crypto-related products here in Australia because of an absence of a regulatory framework. Now, the government having recently come up with some sort of framework here for digital assets.
Mm-hmm.
How's this likely to work?
So you're right. There has been a search both here in Australia, but also globally, to find an appropriate way of regulating the crypto assets space. In Australia, we've relied on falling back on the general consumer protections in the law, which many have identified as being inadequate. So that's resulted in Treasury releasing a discussion paper and consultation which proposes bringing crypto assets into the existing financial product regulatory regime. So it's an interesting proposal put forward by Treasury. It does have the benefit of resting on that existing regime, which is well known by those in the financial profession. Some critics of it will highlight that it may provide a facade of legitimacy to some of these assets, where some voices are critical of the underlying legitimacy of some of the crypto assets out there. So there's a little bit of caution in some corners that in classifying crypto assets as financial products, it could be seen as a form of endorsement or credibility given to them.